Hi, I'm Todd Schneider, and I'm an ACTEC Fellow from San Diego. With me today is Michelle Graham,
Hi, I'm Michelle Graham, ACTEC Fellow, also from San Diego, California.
and we're going to be talking to you today about community property and estate planning. So, Michelle, what is community property?
So community property comes into play, and we've got 9 states in the United States that are community property states. Community property means that spouses who acquire property during marriage own property equally, 50-50. That means that one spouse on death can leave his or her share as he or she wants, and on divorce it typically is divided 50-50 as well. Separate property, on the other hand, is property that's acquired during marriage by gift or bequest, and also property that's brought into the marriage. And then we have something called quasi-community property that not everybody's heard of. Quasi-community property is property that a couple who's domiciled in California acquires while in California, and that's located in a common law state, so a state other than a community property state.
And so, Michelle, what are some of the common misconceptions about community property?
So one of the main misconceptions that I see is that for example, a couple from a common law state who buys property in California, that property will automatically be community property. That's not the case. If they're not domiciled in California, they're not going to be subject to our community property rules.
And so, what happens if a couple who's domiciled outside of the state of California or any other community property state moves into a community property state such as California, and they've acquired property in, let's say, a state such as Florida, that's a common law state?
Right. So if they come to California and they have been married and they're bringing their assets into California, that will be considered quasi-community property. And it will most likely then be considered community property in California. Also, if they have separate property, just because they're moving into California doesn't automatically make it community property. Something needs to be done in order to what we call change the characterization or transmute the property from separate property to community property.
And so what happens if you have a couple that lives in a non-community property state, but they acquire property in California or another state, such as California, that's community property? Is that property automatically become community property in that other common law state?
No, it doesn't. In order for that property to be considered community property, the individuals would need to be domiciled. And that's a term of art in California. It's defined under our probate code, but they need to have California be their permanent place where they intend to remain. And so if they're simply purchasing a vacation home in California, we see that quite a bit. Just because they buy property in California doesn't automatically subject them to our community property rules, which of course then come into play on death or divorce.
And what happens in the event that a couple decides to change the character of their property? Is that something that they can do by simply signing a piece of paper or recording a deed? Or is there some other type of document that needs to be recorded?
Yeah, it's certainly something that couples can choose to do. So if they come into California and they have separate property, for example, and they want to change that to community property, they can enter into an agreement to change that characterization. And you mentioned a deed. So most often with real estate, you would have a deed that would be recorded that changes the property and clearly states on the face of it that the properties are now changing it from an individual's separate property into the couple's community property. And when it comes to the other property that the couple owns, we would typically recommend that they enter into a marital property agreement and that both spouses be represented, and so they can have fair representation and explain what the rules are. And that's drafted in accordance with the family code in writing and fully explained what they're changing the characterization of their property to.
And Michelle, are there any specific tax benefits to having community property other than you mentioned the probate situation, and you mentioned death and divorce? Are there any other benefits as well?
There are. One of the benefits with community property is that the property receives a full step up in basis. So what that means, if the couple purchased shares, for example, that were worth $100, and on the death of the first spouse, they were worth $1,000, the new basis in the property will be $1,000. Thereby, the $900 appreciation goes away completely and will not be taxed. So that's a big benefit. And then when the second spouse dies, it'll get another step up in basis if the property has appreciated again.
And are there specific rules with respect to income that's earned during the marriage off of community property or separate property? For example, if I were to bring in a business into the marriage and I'm working at that business, do I have community property or do I have separate property with respect to the income that I'm earning?
Yeah, you've probably named one of the harder assets really to deal with. The easier assets, if you have income from separate property from like dividends or interest, that will track the asset. So if the asset is considered separate property, the income from the asset will be considered separate property, unless of course the couple agrees otherwise. And the same thing with community property. The income will be community from a community property asset. The tricky asset is the business, because what happens is you're putting time and effort into that business. And the question will be whether you are adequately compensated. And so even though you thought, well, hey, I brought this business into the marriage, this is my separate property, that's the way the laws work, there could be an argument, most often we see it on divorce, that the other spouse, the non-working spouse, has somehow acquired a community property interest in that because the income and the work and the personal services that you put into that business were community property. But good question, tough answer though.
And with respect to separate property, is that something that I can do whatever I want with it? Or are there any restrictions when I pass away or in the event of divorce? Does that become my property automatically?
Separate property is your property, and you can certainly bequeath that to whoever you'd like to, yes.
Well, very good. I think on that note, thank you very much, Michelle, for those wonderful answers on community property.
My pleasure, thanks.